Welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be taking up to 3 o'clock riveting testimony in the Rosenbaum case. The medical examiner on the stand. Let's go to court. Okay, welcome back to the Law and Crime Network. I'm Bob Bianchi. Great opportunity as it would be to bring in my two great guests. As you guys know, as always, my bestie, Gene Rossi, hashtag 4041, 30 years at the DOJ, an unbelievable trial record. Welcome to the show.
Good afternoon. Good to be back.
Okay, and right from Georgia, freshly minted here, her first appearance in studio at the Law and Crime Network, Ashley McMahan from the Law Ladies. I was looking up this bio. I love it. Everything about your bio is Georgia, Georgia, Georgia High School, Georgia College, Georgia Law School, Georgia great awards. You were in the Georgia District Attorney's Office where you prosecuted thousands of cases and have an incredibly successful trial career. Welcome to the in-studio version of Law and Crime.
Thank you so much, Bob. It's great to be here.
Okay, awesome. Guys, let's start with something that Ashley and myself were talking offline. Gene, having prosecuted many homicide cases, I cannot think of one where I put the forensic pathologist on as the first witness. Actually, to be honest with you, many times I buried them in the middle of the case because the mechanism and cause of death were clear. Why wasn't in this case, however? I do a little bit of a different thing here because of the manner in which the defense is positioned in this case. Why wasn't this person the first witness called?
You know what? I don't know why, because she's pretty good. And I heard you and Ashley talking. She adds a little zest and vitality to the case, unlike some forensic pathologists you folks have had where, you want to take a little daytime nap. So I don't know why they didn't start off her being the leadoff hitter in the top of the first inning.
Yeah, Gene, Ashley, that's what I used to call wanting to put a knitting needle in your eyeball when the person is testifying because you feel like killing yourself. But you brought out this point, and I was thinking the same thing. This witness is basically saying these injuries that we're talking about, these are not consistent with an accident. The ear injury is consistent with either pulling or forcefully, and these other injuries are consistent with abuse. Thoughts?
I mean, Dr. Laura Darasaw doing an amazing job here, just coming in and absolutely destroying the defense's entire case. I am also shocked that she wasn't put up very early in this case because I think you kind of have a slam dunk for the prosecution after her testimony. Every other witness's testimony in this case should have been used to back up this forensic pathologist's initial testimony.
Yeah, Gene, to Ashley's point, and we talk about this all the time, and you train so many prosecutors as I have, this is the way you go about it. Just like Ashley said, she tees up every other witness, then the jury can put into context, look at all these crumbs that are leading up to this eventual death that the pathologist talked about. I agree. What do you think, Gene?
Oh, absolutely. And as you both know, that when you present a case, if you have more than a couple witnesses, you try to present them in a tactical and strategic order so that each building block makes sense as to why you're calling the witness in this particular order, unless you have work issues or things like that, vacation. But she's pretty good, I got to say. The punchline is she's pretty darn good.
And Ashley, we always go into our chat room, and because they're our second jury, I always say that if I'm ever trying a case that's profiled on the Law and Crime Network again, I'm hiring somebody just to look in the chat room as to what these folks are saying. They think that she's a tremendous witness. And like we talked about before, sometimes when you're preparing your case, you got to look at who the strengths of your witnesses are that are testifying. She's got it all. She sets it up for all the other witnesses, like you said, and she's very entertaining in the manner in which she's delivering it. I mean, funny, but we were looking at it like, oh my God, that's really, really interesting testimony.
Well, I mean, the bar is very low for a forensic pathologist to be funny or entertaining on the stand, usually as long as they're not, like you said, boring the jurors to death, or you don't have a couple of jurors taking a nap. That's a huge win. But in this case, she's going beyond the four corners of the document, of her report in this case. And like we were discussing before, that's an amazing thing to have your pathologist do. And I think it's a big win for the state on this, and I don't know that they're utilizing this witness as much as they really should have in this case.
Ashley, I want to pick up on that point you just raised, the four corners of the report. And I've had this before, where the pathologist refuses to do anything other than say the basics and the science, and that's it, but they don't want to draw conclusions. Yet I've had other pathologists who really give you insight into the mechanism of the injury itself, and their testimony can really, therefore, be profound as a prosecutor, of course, if it supports your case.
Right. Well, I think in this case, or in most cases where pathologists refuse to go beyond the four corners of the document, it's because they're afraid of raising an objection from the defense, which oftentimes happens. It doesn't seem like that's what's happening in this case. And so I think, Dr. Laura's just kind of going with it and seeing how far she can push. And she's doing a great job because I think she knows exactly what happened to this poor little girl.
So, Gene, to Ashley's point there, she tees up another great question. She's doing a great job already in studio, Gene. I don't know. She may become my next bestie, Gene.
Yeah, well, I'm not happy with her because her Atlanta Braves beat my Nationals last night.
Well, listen, with all the flirting you've been doing with Linda Kenny Bodden and all the other Jesse Weber, I don't know. I'm just thinking that maybe my Georgia girl over here, the law ladies, it'd be a nice little compliment. But anyway, Gene, seriously, to her point,
yep.
These are like doctors who don't want to go beyond the four corners. Why is the defense not objecting to this? I don't think it's bannable, but do you think that they at least try to throw a little interjection in there to try to shake it up, or are they just saying, let's just pass this and move on?
Pass this and move on, because, you talk about the four corners of the report. The court and a witness does have discretion to go a little bit beyond those boundaries, as long as it's consistent with the punchlines of the report. But if I'm the defense attorney, I'm not gonna do a destructive cross of this witness. It's not gonna do anything for their clients.
Sometimes you gotta know when to fold them and know when to hold them. Gene Rossi, Ashley, we'll be back. We're gonna do some business here at the Law&Crime Network. Don't go anywhere because this fascinating witness is still on the witness stand. Okay, there you go, 911 call. Ashley, well, you're listening to that as you as a lawyer. You want to listen to it like a juror first. And you're listening to that as a juror/lawyer. Are you persuaded that she is somebody that was in the midst of an emergency, or is this some masterfully concocted story to help her get out of trouble for having harmed that child?
I got to be honest, looking at this just as a juror, as a layperson, somebody that doesn't necessarily know the law, looking for the emotion in her voice, it just doesn't sound like somebody who's got a child that is potentially choking to death. She even goes out of her way to say in the beginning of the description, I've got a toddler here, and then she goes, oh, wait, foster child. And she makes that distinction, which I thought was interesting. Any mother in the middle of an emergency with a toddler is not going to wait and make a distinction on whether or not this is her child to an emergency responder if you're trying to get an ambulance to the house. That just doesn't make any sense. I'm worried that I may have broken a rib. I don't know how to do this CPR. However, it doesn't look good. She's breathing, but it doesn't look good. Again, it just doesn't sound like somebody who's in the middle of an emergency.
Yeah, interesting, Ashley. You're the first person that brought out that little permutation about the foster care scenario. Right. Gene, does that persuade you? When Ashley said that, is that something as a prosecutor you would be bringing out in summation?
Ashley's a machine. I totally agree with her. That foster thing, I didn't even think of that. The rib thing, and you're going to get a jury instruction, I'm sure, on false exculpatories. And this 911 call, I don't know how many minutes it is 100% false exculpatory, because you don't hear in her voice that quiver, that nervousness, that sense of trauma when your child's about ready to die. It seems very antiseptic.
Yeah, well, so that's another one that Gene Rossi, what did you say, that Ashley's doing what?
She's a machine.
She's a machine. Okay, so I'm asking the chat room, should I abandon Rossi since he's been flirting with all those other hosts and make this my new bestie? Let me know, Kit. Do the tally. Should it be Gene or Ashley? Okay, look, great commentary by both of you guys. Love having you on. But the 911 call was not the only piece of pivotal evidence in the case. It's important to also understand that the medical examiner, who is still on direct examination, now watch this, watch how this came together, starts talking about what was described by the mother on the 911 call, vis-a-vis that it sounds more like a seizure as opposed to a choking event. Let's take a listen. Okay, so, Ashley, that's the sister. I'm not sure how compelling his child, a cute kid, you can just tell, right? The interviewer doing a very good job. And let's talk a little bit about how interviewers have to be very careful that they don't suggest answers to a child at that age. And by the way, the kid apparently is looking at some news accounts or knowing something about the facts of the case, which is never good for a prosecutor.
Right, and this is a problem that comes up frequently with young children that are going to testify in cases of this magnitude. First of all, you have to worry about the fact that she may have suffered traumatic events while she was in foster care as well. So you've got to be careful when you're dealing with that. That's why we're doing an audio recording of her interview, because she's giving this interview somewhere in a safe space, probably, with two interviewers and with a bunch of toys around, and they've made her feel comfortable. But you can even hear in some of her answers to her questions, Miss Jennifer pushed the food down with a knife. Well, how do you know that? Did you hear the news about her? Clearly, this child, it's taken a year to, get this case to trial. Of course, she's going to have heard things, and it's hard to tell what a child has just heard from other people, from family members, from the news, just talk around her. They're like little sponges. They absorb all this information, what she's heard and what she now believes is something that she may have actually seen but didn't really occur. So you got to be real careful with these types of witnesses. Yeah,
agreed. Gene, I think the best thing about her is the injuries, the physical injuries that support the state's case. But to Ashley's point, and I think it was the seminal case on this was the Margaret Kelly Michaels case. It's referred to as a Michaels hearing. It was out of New Jersey, where a number of kindergartners, I believe they were, came forward about sexual assault allegations of Ms. Michaels that were later determined to be untrue. And it was striking the manner in which the interviewing took place suggested to the kids answers. And they were so consistent, and there were so many of them, everybody just assumed, well, Ms. Michaels must have done this, until it was later determined that she didn't. And they came up with all sorts of protocols on how to prevent what Ashley is talking about from happening. And by all estimations, this cop seems like he's following those things. He's not going down the rabbit hole. What do you think?
Oh, absolutely. But I got to say this. I don't care if you're 88 or 8 years old. The rules of evidence still apply. And when Millie said that I heard or someone told me that she was given to chicken with a knife down her throat, or suggesting that, how in God's name is that not objectionable unless she observed it? If she didn't observe it, or it wasn't something the mother said to her, that should be stricken.
Yeah, that is surprising, Gene, and I guess we'll find out whether or not the defense, what the defense's idea is here, because the defense clearly knows what they're doing. Real quick, Ashley, on the point of the defense, because Gene and myself talked about this last week, it is surprising to me, shocking, and as this case is developing more, even more shocking, that one defense lawyer, one defense team is representing two defendants in that courtroom that have differing defenses and differing charges. So that husband's getting the raw deal here, in my opinion.
Oh, I got to tell you, Bob. Yeah, the husband's being thrown under the bus by being represented by the same attorney or the same even public defender's office as the wife in this case. It blows my mind. This is a simple phone call to the Georgia Public Defenders Council to get what is called a conflict defender out there to make sure that the husband's conflicting interests in this case are protected and that his constitutional rights are protected. I don't know what's going on, but clearly there was a conflict with the prosecution in this case, and it wasn't an issue for the state to get two amazing prosecutors from different counties to come in and substitute in. Georgia Public Defenders Council shouldn't have been an issue on this. So I'm not really sure. I don't know if this is going to be an issue on appeal. I should hope it would be for Mr. Rosenbaum in this case, but we'll have to see what's going on.
Yeah, and great point. And Gene, you don't want to go in with co-defendants and having an antagonistic defense. I get that. But at a certain point in time, all the charges for him rely upon his knowledge of what she was doing. And as a defense lawyer, I would be getting up there saying, just like the school was fooled, just like the neighbors were fooled, just like the doctors were fooled, just like everyone else that came into contact were fooled, so was he. These events were occurring when he was not present. He had no idea, and he was believing the lies of this very sophisticated person who, by the way, is going to law school, is not a dummy. That would be the argument that you would imagine his lawyer would be making. Or in the alternative, Gene, sorry to go on, that if you were to find, ladies and gentlemen of the jury, that she did these things, she did them under the radar and he didn't know about it. But that's not happening here. That lawyer can't do that.
That's a great point. But you know whom else I blame? The judge. I had a drug case where the defendant was willing to waive any conflict with the defense attorney, but I still made a motion with the court because under U.S. Federal Circuit, Fourth Circuit law, the judge can say, you know what? I don't care if you're waiving a conflict. I don't want one attorney representing two people with divergent defenses.
Yeah, it's a basic thing. And listen to this Gene Rossi, man. He's bringing the heat from all sorts of circuits. You can't beat this guy. And Gene, just for the record, so it's clear, our chatters have spoken. Nobody wanted to make the deal. Nobody wanted to say whether or not I should abandon you for Ashley, except one person said, kind of like use an analogy, why would you leave an A team? So I'll guess that that's one vote. I'll throw that as a vote in favor of you. Gene Rossi, you're still going to be my bestie, but she's going to be backup bestie. Okay, listen, guys, let's have a little fun here at the Law&Crime Network. Millie's counselor also is going to be was a very relevant witness in this case. Let's listen to a little bit of what she had to say, because I think it's going to be pivotal in what the prosecution's going to do in summation. Welcome back. Okay, so we're going over the Rosenbaum case. They're at lunch break right now, so it gives us a great opportunity to talk to Ashley and Gene about the most important parts of the testimony. Gene, while we were on break, I asked, is there anything that you're interested in discussing? Now, we had previously been talking about this idea that there's only one lawyer representing two defendants in this case, and that to me, and I think to my colleagues here, that the second lawyer, if there were one for the husband, could have a defense that the first lawyer for Jennifer can't raise, and that, to use Ashley's term, he's getting thrown under the bus. Gene, then we listened to the counselor talking about Millie's, or Layla's statements, or Millie's statements, I forget which one, of the children. It was coming out, and we were asking the question, how legally is this allowed? Because it's really rank hearsay without an exception. And then you brought up a very powerful point, going back to the idea of representing two different defendants, and potentially, Gene, maybe a severed trial, a separate trial, is that the husband likes that testimony. That's good testimony for the husband that the counselor gave, but bad for Jennifer. Thoughts?
Right, and this is the problem of having one witness represent two people, a couple, because if I were representing the husband and Ann McCullough got on a stand and had all this hearsay against the wife, go for it, let it all in. Because all it does is it protects and insulates my client from the ultimate decision that she murdered Layla, and the husband had nothing to do with it.
Yeah, and what do you think about that, Ashley? Do you agree that that testimony helps the husband? And if so, like, how does the defense lawyer now, who's representing Jennifer and him, get up there and make the argument that testimony of that counselor was really bad for Jennifer, but really good for my other client, the husband?
Well, that's the exact problem here, Bob. I mean, they can't make that argument. And I don't know if this is a situation of stand by your woman, you know, in that he's saying, okay, look, you know, I realize there may be a conflict of interest. I'm hoping somebody at the public defender's office at least explained that to him. If they didn't, we got serious problems. And even if he was saying, like Gene was saying with one of his former clients, they're willing to waive that. You know, the judge should not have allowed this to happen in the first place. So even if, you know, when you're representing somebody and they're a defendant and they've got a conflict of interest and they have, you know, a relationship with their co-defendant and they really don't want to, you know, use or throw any sort of guilt their way in order to, you know, help themselves, sometimes you have to advise them, hey, look, this is the best defense we have. It's kind of the only route we can go. And if this is the case where he's saying, no, I don't want to do that, at the end of the day, you do have to listen to what your client wants, because it is their case.
You know, Gene, and you know, Ashley is really tearing it up here. I'm not going to lie to you, but I'll add one thing. As the lawyer, I would say I refuse to represent both of you. You either get another lawyer or I'm out.
Absolutely. I mean, there's blame placed on a lot of people, and the more I think about it, I think this is going to be an issue on appeal. Mm-hmm. And it's like one of those other cases, the 8-ball case.
Yeah, Gene, I'm sorry to cut you off. It's going to be something that's going to come up in appeal, and it may have developed during the course of the trial, but may have fundamentally affected the defendant's rights. We got to go to a short break. We'll be right back. Stick with us.